Hello friends, myself Mohit and I am going to dictate you Steno legal matter. Please subscribe my channel and press the bell icon for more dictations. So be ready for the dictation. 5, 4, 3, 2, 1, start.
Section 7 of the SAD Act and Rule 12 of rules framed under the SAD Act will also have to be kept in mind. Stop. In the Supreme Court has, while dealing with Section 35 of the Indian Evidence Act, observed as under: to render a document admissible under Section 35, three conditions must be satisfied. Firstly, entry that is relied upon must be one in a public or other official book, register, or record. Secondly, it must be an entry stating a fact in issue or relevant fact. And thirdly, it must be made by a public servant in discharge of his official duty or any other person in performance of a duty specially enjoined by law. Stop. An entry relating to date of birth made in the school register is relevant and admissible under Section 35 of the Act, but the entry regarding the age of a person in a school register is of not much evidentiary value to prove the age of the person in the absence of the material on which the age was recorded. Stop. In case the Supreme Court reiterated the same view, in that case the school leaving certificate was not issued in the ordinary course of business of the school. Stop. There was nothing on record to show that the date of birth was recorded in a register maintained by the school in terms of the requirements of law as contained in Section 35 of the Indian Evidence Act. Stop. No statement was made by the headmaster that either of the parents of the appellant who accompanied him to the school at the time of this admission therein made any statement or submitted any proof in regard thereto. Stop. In fact, entries made in the school leaving certificate evidently had been prepared for the purpose of the case. Stop. The headmaster had not verified the age when he made entries in the register. Stop. The register was not produced in the court. Stop. The Supreme Court observed that if any register in regular course of business was maintained in the school, there was no reason as to why the same had not been produced. Stop. In the circumstances, the Supreme Court did not accept learned sessions judge's report declaring the appellant to be a juvenile in conflict with law. Stop. In case respondent 1 therein examined AW1, who stated that he looked after the administrative work of the public school and this work was previously done by his son who had expired. Stop. He further stated that date of birth of respondent 1 was mentioned in the admission form as 5/10/1988, and in this admission form the uncle of respondent 1 had put his signature, which was marked by the court, and on the basis of this information in the admission form an entry was made in the school register that the birth date of respondent was 5/10/1988. Stop. AW1 in his cross examination, however, could not say who had filled up the admission form and on what basis the date of birth of respondent 1 was written as 5/10/1988, and he had admitted that the school admission was not in his handwriting. Stop. In view of these facts, the Supreme Court, while concurring with its view in case, held that the entry of the birth of respondent 1 in the admission form, the school records and transfer certificates did not satisfy the conditions laid down in section 35 of the Indian Evidence Act, inasmuch as the entry was not in any public or official register and was not made either by a public servant in discharge of his official duty. Stop.